Okay, so I've set up the recording and I will start the webinar. Excuse me. So I'll start the webinar in 3, 2, 1. Good afternoon and welcome to another webinar of the America-Europe Chair on Technology, Innovation and International Regulation. My name is Joana Gomes Beirão and I'll be moderating today's webinar. Today we are fortunate to have Mr. Jan Kleijsen and Professor Peggy Valk with us to discuss the Convention on Artificial Intelligence that the Council of Europe is currently preparing. The treaty negotiations involve the 46 member states of the Council of Europe, as well as 10 observer states, where the United States is included. And if the negotiations are successful, this will be the world's first ever treaty on artificial intelligence. So how are the treaty negotiations progressing, and how exactly does this convention aim to reduce the risks posed by artificial intelligence while protecting human rights, democracy, and the rule of law? These were some of the questions we asked our esteemed speakers to consider today, and both of them are perfectly positioned to answer these questions and many more that our participants may have, because they have been closely working on the preparation of the convention from the very beginning. Until February 2023, Jan Kleijsen was the Director of Information Society and Action Against Crime at the Council of Europe's Director General for Human Rights and the Rule of Law. And among other activities, his directorate was responsible for the preparation of the Convention on AI. And Jan is currently part of the advisory board of the Dutch Alliance on AI, which is one of the civil society organizations that have been granted observer status by the Council of Europe's Committee on AI, where the convention is being discussed. So we will start with a presentation by Jan, and our second speaker, Professor Peggy Valk, will join us at the end of the webinar to share with us her personal view of the process in the CAI, so in the Committee on Artificial Intelligence. But I will nevertheless already introduce her. Professor Peggy Valk is a full professor of law and technology at KU Leuven and vice dean for research at the Leuven Faculty of Law and Criminology. She has been representing Belgium in the Council of Europe's Committee on AI and previously served as vice chair of the Ad Hoc Committee on Artificial Intelligence. So she'll be able to share with us her experience in these forums. So thank you, Jan, for joining us today. And as I've said, Peggy will be able to join us afterwards or towards the end of the webinar. Before I give you the floor, Jan, I would just like to let our participants know that they are very welcome to ask questions. They can do so in the Q&A function at the bottom of the screen. We will try a bit of a new format today to try to make it a bit more interactive. So every 20 minutes or so, I will go through the questions that I put in the Q&A, and I'll repeat some questions out loud. So if you have questions, if you are interested in a particular aspect of the negotiations or the convention, you can already mention that in the Q&A as well as throughout the webinar, and we'll go through them every 20 minutes or so. So that being said, thank you again, Jan, for being here, and you have the floor.
Thank you very much, Joanna. I hope you can hear me, and I hope participants can hear me. Sound seems to be good. Very happy to be with KU Leuven again in a different way this time. I had the pleasure to be both a visiting fellow this year and to speak at the summer school on artificial intelligence. So a number of you perhaps followed one or more of these sessions, and if I therefore repeat myself, I apologize in advance. There are, however, since the summer school also some new developments which you will not have heard from me. So in any case, I hope you will stay tuned in. Joanna has already kindly introduced me. I worked for the Council of Europe for 40 years and indeed was responsible for the starting of the work on artificial intelligence, because the area I supervised dealt with information society, internet governance, data protection. And of course, you will then understand that AI was a logical next step to be dealing with. I've been asked to speak to you about the current work of the Council of Europe on the treaty. Indeed, as Joanna said, well, not only if, I'm sure it will be completed, once completed, will be the world's first legally binding global treaty, we hope. Say more about that in a moment. Global treaty on artificial intelligence. But in order to understand why the Council of Europe is working on this and what is happening, allow me to rewind for a moment and say a few things about the organization and its previous work in order to better understand why today this pioneering activity on the world's first legal instrument on AI is actually happening at all in Strasbourg. Why Strasbourg? Why the Council of Europe? For those of you who are not familiar with all these different European institutions and the different acronyms and abbreviations, the Council of Europe is the oldest political organization in Europe. It was founded in 1949 as a reaction to the events of World War II, on the one hand, and also to provide a counterweight to the totalitarian system that had, after World War II, through the occupation by the Soviet Union, the totalitarian system that was imposed on Central and Eastern European countries. The Council of Europe was set up and still strives to protect human rights, democracy, and the rule of law, the holy trinity of the Council of Europe. Unlike the European communities, which was set up slightly later, although largely by the same people that also set up the Council of Europe, I should add, the Council of Europe started to work towards these three main objectives through law. So whereas the European communities and now the European Union have taken an economic perspective, economic integration, to ensure cohesion and the absence of war, stability on the European continent, the Council of Europe has done so through, and continues to do so, through legal cooperation, with the idea that if states are part of a network, an intricate network of legal obligations, a web of legal commitments to each other, there is, first of all, it's less likely that there will be conflict between them because there are so many legal options to resolve disagreements. And secondly, of course, to create a common European standard as regards the law. I think that is important. And of course, the higher the standard, the better. Since its creation in 1949, the Council of Europe has established some 200 treaties. Now, you may say 200 treaties is not very much in 75 years, but if you would calculate the number of these are multilateral treaties, which means they bind a number of states. Some of them bind all member states of the Council of Europe, like the European Convention on Human Rights that you probably heard of, with the court in Strasbourg. Other treaties are à la carte, that is to say, they're not obligatory. States may accede to them, and because of that, a number of them have it varies the number of parties to a convention. But if you were to calculate how many bilateral treaties you would need, you would be close to 30,000 bilateral treaties to settle all the matters that are now contained in 200 texts. So already from that point of view, as regards unification of legal standards, I think the Council of Europe has made a real contribution. To come back to today's theme, artificial intelligence and technology. So I already explained, Council of Europe deals with human rights. So that's an angle, human rights, rule of law and democracy. I'll give some examples in a moment, but I think many of you can immediately already think about issues in the field of AI that would have to do, that would impinge upon human rights, rule of law, or democracy. The Council of Europe, in these 200, when it established all these treaties, at a very early stage realized that technological developments had an impact on human rights. And therefore, now 41 years ago, the organization established the world's first treaty, adopted the world's first treaty on data protection, so-called Convention 108, which is in many ways the grandmother, the precursor to the GDPR, that I think many of you are familiar with, the European Union's data protection regulation. But Convention 108 remains, although it was actually updated a few years ago. And the convention brings together far more states actually than the Council of Europe. Nearly 60 states have ratified, and some 30 are observers in the work of the so-called Data Protection Committee, the TPD as it's called. And 41 years ago, now everyone speaks about data protection, but please note that 41 years ago, there were hardly any countries in Europe or elsewhere that had any data protection legislation whatsoever. So the Council of Europe Treaty at the time was really pioneering, as is the work on AI today. In between, 21 years ago now, the Council of Europe established the world's first treaty on cybercrime. It remains, to this day, the only international treaty regarding cybercrime. It brings together no less than 68 countries, including the United States of America, which ratified this treaty. And recently, this year, Brazil and Nigeria joined. This treaty has now 68 parties on all 5 continents, so a truly global treaty. And in last year, 22, when I was still director, cooperation activities took place with 130 countries worldwide. Well, if you take into account that the United Nations have some 200 member states, you would agree that 130 is not bad for a regional organization as an outreach. So on this basis, the Council of Europe started work on artificial intelligence around 2018. It was born out of its immediate work at the time with regard to the internet. There is no internet treaty, the Council of Europe, you will have noted, or you would note if you looked it up now, but the Council of Europe has adopted a whole series of recommendations based on its treaties, based on the Data Protection Convention, based on the European Convention on Human Rights, based on the Cybercrime Convention, policy recommendations in the field of internet governance. And those have been shared with the global community, for instance, at the annual Internet Governance Fora, where everyone that deals with the internet, governments, private companies, civil society, come together to discuss how to manage the world's internet and how to especially also deal with its governance and the rules of the game. The Council of Europe, as I said, started in around 2018 to really look into the question of artificial intelligence, because by then it was clear that the developments as regards this technology were really accelerating. They're accelerating because of 2 reasons: the availability of bulk of mass data, so the collection of data had, by the end of the 2010, so 2016, 17, it was really clear that this was becoming a big issue, big data, big issue. And at the same time, the capacity of microprocessors, of semiconductors, of computing capability generally was accelerating to such an extent that this increase in computing capacity combined with the increase in data really provided a boost to a technology that had already been around for a while, but which was waiting actually for this particular moment. a number of issues, it seemed, were becoming clear because governments began also to delegate to automated systems, began to delegate tasks that were traditionally, and in so many countries still are, carried out by human beings, by civil servants, by judges, by law enforcement. And so the question arose, is it necessary that we establish particular rules for the way governments use these systems with regard to their citizens? Or are the existing conventions, and I gave you 3 examples already, are these existing conventions and all the other rules, the recommendations based on these rules, are they sufficient? The Council of Europe was not alone in asking this question, I should add. More or less at the same time, UNESCO and the OECD started looking at issues of internet governance. The European Union set up a high-level expert group also to look into questions of, in their case, particularly also the economic consequences and the need to regulate AI. So we see around 2017, 2018, a flurry of activities in international organizations, many of them asking actually the same question. What does this technology mean for our citizens? What does it mean for international cooperation? What does it mean for governments? And in the case of the Council of Europe, because of this very particular perspective of the organization, human rights, rule of law, and democracy, what is the impact of artificial intelligence on these core principles of the organization? The governing body of the Council of Europe, which is called the Committee of Ministers, which brings together the once or twice per year the foreign ministers, and throughout the year the states meet at the level of ambassador here in Strasbourg, created what was called an ad hoc committee on artificial intelligence. It's called CAHAI, C-A-H-A-I. I'm spelling it out because you may want to look it up afterwards, because this committee was quite unique in its composition when it was created, because although the Council of Europe brings together states, at the time, I should add a slight intermezzo, a slight footnote here. At the time, there were 47 member states of the Council of Europe, but because the Russian Federation was also a member state, following the aggression by the Russian Federation against Ukraine, the Council of Europe, so far the only international organization to have done so, expelled the Russian Federation as a member within 3 weeks after the aggression to Ukraine, because, and this will not surprise you, given, as I told you, what the values are the organization was set up to protect. So there were 46, now 46 states. The CAHAI body was this committee, this special group of experts on artificial intelligence, brought together government representatives, but not only. Civil society was from the beginning invited to take a seat at the table, and so were a number of companies that had agreed to a digital partnership with the Council of Europe, a possibility that was created around 2016, when companies were invited, those companies that wished to work on digital issues together with the Council of Europe, whilst respecting and promoting human rights, rule of law, and democracy, were invited to join this partnership. And now, as we speak, there are some 28 companies and associations of companies. So it's not just single companies, but also industrial associations. For instance, of internet companies, of telephone companies. We also have standard setters like IEEE from the United States, that are an international body, but based in the United States, that are on board. And from the very beginning, they were given a seat at the table. And the agenda for this committee, the task it was given, was to investigate whether or not, as I mentioned earlier, new rules were necessary in this field of rapidly developing field of artificial intelligence, whether new rules were necessary, or whether existing rules, as found in already established treaties would be sufficient. That work was carried out with some difficulty, I should add, during the pandemic, because the moment KAI started working, COVID struck. Nonetheless, the committee had been given a 2 years mandate, and it managed to provide within 2 years, 2019, it started in 2021, it finished, a so-called feasibility study, where the committee unanimously, and that's interesting because civil society, governments, and the private sector all agreed that existing regulations were not sufficient to sufficiently govern all the various and once again very rapidly developing aspects of AI, but that new rules were necessary. At the same time, in the feasibility study, KAI also gave a number of indications as to how certain areas could be regulated. Perhaps, Joanna, I think I've been speaking now for a while already. This is perhaps a good moment to take stock and to try and respond to some questions or comments, if you have, of course.
We don't have any questions yet. Oh, and as I was saying that, a question came in. We have a question from one of our participants on what effect might big tech companies have on the effectiveness of global AI cooperation regulation. So you've mentioned only the KAI so far, but if you want to take the question more general or specifically, up to you, your thoughts on this. And I'm sure that we are also very interested in hearing what happened after the feasibility study and how things progressed after that.
Of course. Thank you. Perhaps I'll give a preliminary answer to this question, but I will come back to the issue later. It is clear that a very small number of very big companies at the moment have wield enormous power in the digital field when it comes to social media, when it comes to search engines, when it comes to when we speak about artificial intelligence. The whole digital world is governed by a actually relatively small number of very major corporations, quite unprecedented actually in history, that you see so much power in the field of human communication over so many in the hands of so few. It is also clear that poses challenges to democratic societies, and you will have seen that a number of international organizations, in particular here the European Union, have adopted rules to try and have a counterweight to this power. I already mentioned the GDPR, the Data Protection Regulation of the European Union, under which, well, you cannot open any site these days without having to agree or disagree to a whole series of issues concerning your data. That is because of the GDPR. Companies that do not actually, and that's why I say counter, the European Union is trying to counterbalance this enormous power of big corporations, enormous, very substantial fines. To us ordinary humans, enormous fines, given the assets of the companies. One can argue whether they are really big enough, but that's another completely different debate, would take us too far today. But it's clear that there are rules with which international corporations have to comply when it comes to data processing, for instance, these days. The European Union has now the Digital Services Act, which imposes further obligations on big companies. As regards the global treaty, the jury is still out, but I'll come to that afterwards, what the effect of the Council of Europe's treaty will be on big companies. The reason they were admitted at the table was to give them the opportunity to decide, because voting, I should have said this, but you could probably guess, although civil society and private industries at the table, the voting is limited to states. So it's governments that decide, because it's going to be law. This also makes sense, right? It's going to be a treaty. We're negotiating a treaty. Treaty will have to be transposed into, once ratified by Parliament, must be transposed into national law. So these are binding obligations. And of course, it's democratically elected governments that decide to sign, and then democratically elected parliaments that have the last word, because they are the ones that can decide or to ratify, that must decide to ratify before it becomes binding on a state. So the companies and civil society are not there to decide, but it was considered very important to have their views on what was being discussed, and not just to a few. And I think that's also important and this is in a way still also an answer to the question, because the big American companies are all there, with the exception of X, former Twitter. Neither under its current management nor under its previous management, it joined this partnership, but all the others did. But in addition to these big Americans, there are also, and I said there are 28 partners in total, also, for instance, associations of small independent European internet providers, service providers, and European telephone companies, for instance. So there it's not just, the business side is not just dominated by the few players that hold so much power, but there are also a lot of voices from small and medium enterprises at the table in Strasbourg. And as I tried to make clear, it was not for them to decide. It's not for them to decide, but what is going to be decided by states will affect them, their cooperation, and what is feasible, and also issues they flag are important to be taken into account. And what is interesting, and I'll end here with a reply to the question, is that several, in fact, many private companies, both smaller but also big American ones, have actually asked for regulation. Are not opposing it, but have actually themselves asked for regulation. This is not just out of altruism. I think there is a realization that their tools, AI tools, are very powerful, and that therefore it's a matter of also responsibility to realize that you're not going to throw this at the public worldwide without a certain set of rules. There's also, of course, very much a selfish interest. If there is international regulation, and the more global it is, the better, you create a level playing field for competition. Companies, when they launch products, know what the rules are, which of course makes it easier. Liability questions are much clearer. There is, of course, if you play by the rules, you have an umbrella, because you launch your products in accordance with established proceedings, and therefore no one can accuse you of being irresponsible, etc., as long as you respect the various steps. So there's that bit, and it also global regulation also avoids that there is going to be a myriad, whole series of competing or sometimes perhaps very different national legislations. One European regulation already for the Union is much better than 27 different ones for a company that wants to launch a product. And if there would be global standards, that would make it, of course, again, easier to develop a product. A rather long answer to the question, but I'll come back to this particular issue of private industry. But it's a very big issue in this, of course.
We actually have a question touching exactly on the opposite point of what you made. So we have a participant, Caroline, who is pointing out that some companies have said the exact opposite, that more regulation will hamper innovation. So just we are curious to hear what you think of that in the context of the Convention on AI, especially because there is industry taking part in the process.
Yeah, she's absolutely right. And it's also, when you listen carefully, I said some companies, a number of companies argued for regulation, and therefore I fully agree that some of them have argued the opposite. Interesting enough, some of them that have argued for regulation include some of the very big American ones. very vocally asked for regulation. But it is true that there are those that have claimed the opposite. Very recently, in the UK, there was a big event on artificial intelligence at Bletchley Park in the UK, an AI summit, which brought together a number of major industrial nations, together with business, etc. It was interesting in Bletchley Park, where many of you will know Alan Turing, the father of modern computing in many ways, worked during World War II to decipher German secret communications via Enigma. So Bletchley Park was very aptly chosen. And of course, the Alan Turing Institute in the UK, named in his honor, is a very important academic player in the field of and think tank as regards artificial intelligence. To those, and then the UK minister following that conference also said that the UK was going to go take it very easy, so slowly. Easy is not the right word, I think. Be cautious with regulation, because too much regulation would hamper innovation. I think that is wrong. I think it's simply untrue. Think of the pharmaceutical industry. The pharmaceutical industry is probably the most tightly regulated industry in the world. And yet, as we discovered, fortunately, during the COVID crisis, is also one of the most innovative industries in the world. But it is very strictly regulated to ensure that innovation is not harmful, but beneficial. And but in no way is innovation hampered by regulation. I would claim, and I would join those companies that actually say so, that good regulation, clear regulation, provides for, enables, makes it possible to have good products, safe products, and also products, in this case AI systems, that people can trust. So, and as I said, think of the pharmaceutical industry. You can also think about banking. There are several other sectors which are highly innovative. But I think pharmaceutical is probably one of the most clear examples where you can see that regulation and innovation can go hand in hand.
Thank you, Jan. Perhaps we have still quite a good number of questions, but I'd suggest that first you can maybe tell us a bit more about what happened after the feasibility study, and then we go back to some more questions, if that's okay with you.
Absolutely, yes. And many of these themes, of course, are very closely linked. And some of the questions that were raised, I'll come to when actually discussing what happened next. So after the feasibility study had been transmitted to the governments of the Council of Europe, they decided, in accordance with the unanimous view of the CAHI, of the committee, to start working on something new, on an additional treaty, a new treaty, and to that end, not very imaginatively perhaps, but clearly set up a committee which was no longer an ad hoc committee, but was now the Committee on Artificial Intelligence. So we went from CAHI to CAI, CAI, Committee on Artificial Intelligence, which brought together the same partners as before. So again, in this case, perhaps even more importantly, because CAHI was an advisory committee. It was set up to in a way, academically, look at these issues. What do you think? Should we not? And if we should, what do you think could be in it? In other words, they were drafting a recipe in cooking analogy. They were not cooking the dish. CAI, on the contrary, was set up to prepare the dish. And again, though the governments of the Council of Europe agreed, I think wisely, to also, when it came to the cooking, to bring the civil society and private industry on board, which, by the way, enables me to still be involved in the negotiations, because having had to leave the Council of Europe because of age discrimination this year, I was appointed to the advisory board of a Dutch NGO, a Dutch foundation, which has observer status, formal observer status, and in that capacity, I'm now still involved in the work, so I can tell you a bit about what's going on. In addition to the regular observers of the Council of Europe, perhaps that's something, you said it, Joanna, but there's a slight distinction in the states you mentioned, because the Council of Europe has generally, for all its work, 5 observer states, the Holy See, Japan, Mexico, Canada, and the United States. States that have a regular presence here in Strasbourg. They're always in the meetings of the ambassadors. They can participate in all the committee meetings. So they were there from the very beginning. But already in the case of Kahai, we had the government of Israel that, although it's not an observer state of the Council of Europe, but in view of the subjects that were being examined, asked whether it could be part of that. And this was agreed. The same for Kai. Israel also asked to be part of it from the beginning. And now, very recently, we have seen a number of South American countries that you just listed, that again, on an ad hoc basis, they're not regular observers here in Strasbourg, but they asked, can we join in these negotiations? We have 4 so far, but we expect there are a number more that have reached out, and we think that in the coming weeks or months we will have other countries making formal requests to join the negotiations, which of course is very encouraging, because from the very beginning the idea of the Council of Europe has been that the treaty it will be working on, should go beyond the borders of Europe, should be inspired, for instance, by the Cybercrime Convention, as I said, where we're active in 130 countries. So really a global, setting a global standard. Now already I'm going to answer a question that some of you may have. Okay, Jan, but why the Council of Europe and why not the United Nations, for instance, on this? That's the global standard setter, right? Council of Europe treaties can be negotiated quite rapidly. The Council of Europe holds the Guinness World Record for the fastest treaty ever, following Bataclan, the terrorist attacks, Charlie Hebdo and Bataclan in France, which many of you and all of you will sadly remember. The Council of Europe drafted, adopted, and made effective a protocol, but basically a protocol is also a treaty, to its terrorist convention on foreign terrorist fighters, and it did so within 6 months. So at the time there were 47 member states, and then within 6 months the treaty was ready. In the United Nations, it can take 10, 20 years before a legal standard is adopted, because of course we're speaking about a global community where we also, to be realistic, know there are a number of states who have no interest in human rights, rule of law and democracy, and in values. So coming to something meaningful really takes a very long time. And also because of the number of states and the characteristics of states participating in that process, what you end up with is often the very, very lowest common denominator. So a really very, very low standard. Cybercrime, for instance, I said the Council of Europe has I mentioned this earlier, it's to this day the only treaty on cybercrime. Within the United Nations, negotiations are going on cybercrime, but they're not advancing very rapidly. And there are also, I think, real concerns as to the level, the standard that treaty, if it ever sees the light of day. But even if it were adopted, and it's a very big if, whether the standards would be in any way comparable to those of the Council of Europe's treaty. So both because of speed and because of content, the Council of Europe has taken on this role well beyond Europe's borders, and as I said, with the full support and buy-in participation of non-European states. So this committee, come back to artificial intelligence, this committee was set up in the beginning of 2022. As I said, Kahai's feasibility study was the end December of 21, so beginning of 22, last year, the Committee of Ministers set up the Committee on Artificial Intelligence, and that has now been going on for nearly 2 years, and has in fact produced a draft which will be examined next week in one of the last meetings of the committee scheduled. not the last, but one of the last meetings, on what is called the Framework Convention on Artificial Intelligence, Human Rights, Democracy, and the Rule of Law. And that convention, what you can see, the July draft is public. Since then, and you can find it easily on the internet. Since July, of course, negotiations have continued, and they will continue next week. I cannot share with you the very latest proposals because the committee meetings are what is called in camera, so behind closed doors. They are confidential. But fortunately, the committee has agreed to make earlier drafts, and the draft of July gives you a very, very good idea of what's going on, to make these drafts public. And I'll explain a bit in the coming minutes what you will find in this treaty, in this draft treaty. And although I cannot give you the exact content of the proposals that are currently being discussed, what I can share with you are some of the main issues that are on the table, because these issues as issues, it's not exact wording, and I'm not going to say who said what, but the issues have been widely reported in the press, and I can therefore share that with you. Let me say, though, also immediately to answer already in advance, to anticipate a question you may have. Jan, very interesting, but what about the EU AI Act? No, aren't you competing with them? Is there no duplication? I don't think there is duplication. It's true that the EU AI Act is a very important legislative initiative in the field of AI. But there are a few distinct differences to the Council of Europe, which to my mind should lead to the conclusion that the two instruments are very largely complementary. Important, each of them, but complementary. The EU AI Act was born as an initiative by the European Commission for market regulation. So the original idea behind it, born out of the high-level expert group that I mentioned earlier, the think tank, very much similar to CAHAI, if you like. European Union also went in two steps. First, in a way, an academic exercise to see what could be done, what might be necessary. So it was market regulation to ensure that AI products on the European market are safe and that there are a number of rules attached to them. Then in the course of the process within the European Union, a number of human rights considerations were indeed added, and especially credit, I must say, to the European Parliament, that once it became involved in the proceedings, added quite a few human rights standards. But the object is still of the AI Act to ensure that the products are not harmful to individuals. The Council of Europe's approach is that the use of AI by governments and possibly by private companies, and I'll come to that in a moment, why I make a distinction, but there is agreement, and I can tell you there is agreement between everyone at the table in Strasbourg or on the Council of in the Council of Europe's negotiations in CAI, that when governments use AI or outsource it, when governments ask private actors, but on their behalf to use AI, that there should be regulation and there should be certain standards. So it's a different approach. It's a complementary approach, but it's a different approach to the European Union. What should also be borne in mind is that the EU AI Act will be legally binding, once adopted and once in force, on 27 countries only. Now, it is true, there is the so-called Brussels effect, and it will no doubt influence others beyond the European Union, but legally binding, it is only for European Union member states or those that are active in these European Union member states. So that's 27. The Council of Europe already to next week, we're sitting at the table with 56 countries. So more than twice as much, including very big players. I mentioned the United States, Japan are at the table, Mexico, Canada. So several South American countries, other South American countries than Mexico now. So a very different geographical scope. Nonetheless, it is important to ensure, I think, complementarity as much as possible. This is guaranteed, on the one hand, by the European Union negotiating through the Commission in Strasbourg. So the 27 member states actually coordinate their positions, and it's the European Commission that speaks at the meeting. So that makes sure that, the approach, because both negotiations are ongoing, of course, that's another aspect, something I haven't mentioned, but I think you're probably aware of that. And they're complementary processes. They're not yet complementary products, because neither product is neither dish has been fully cooked, if you like. The EU Act is still under negotiation, and there are now some important hiccups, to which I'll come in a moment again. And the Council of Europe negotiations are also still ongoing. So the idea very much is that there is as much convergence as possible, although there are complementary approaches, but that when it comes to definitions, when it comes to particular understandings within these, within both, that it should be as harmonized as possible. I say as possible because, of course, you will understand that some major non-European players in Strasbourg would not automatically accept to copy and paste wording, which is European Union wording, right? Because they have different systems, and what is agreed in Brussels, of course, doesn't bind them. But we hope very much that it will be taken into account, and that where possible, the wording will be as closely aligned as possible. So, and in any case, that there are no contradictions between the two, because the 27 that agree in Brussels are all also member states of the Council of Europe. So it's important that what they agree in Brussels is in any case not contradicting what's happening in Strasbourg, and likewise. I think that is important to bear in mind. At the same time, the work I mentioned at the very beginning, UNESCO, OECD, notably also OECD definitions, are very much taken into account both in Brussels and in Strasbourg. Just to reassure you, international organizations do speak to each other. And at the meetings in Strasbourg, for instance, next week, UNESCO and OECD will be present in addition to the European Commission. So these various international bodies also sit at the same table, and Council of Europe representatives attend meetings of the OECD and UNESCO in Paris as well. So there is a real concerted effort to move along the same lines. Very recently, you will have heard that the United Nations Secretary General has set up also an advisory body, high-level advisory body on artificial intelligence. Very pleased that one of my colleagues at ALAI, Professor Virginia Dignam, has been appointed by the United Nations Secretary General as one of the members. She's also very well aware of what's happening both in Strasbourg and in Brussels. So we hope that also within this UN context, the work will be promoted. I don't know whether you want to have a short opportunity for questions, Joanna, now on this introductory.
There was precisely a question on the EU AI Act, on the OECD UNESCO initiative. So you have perfectly answered that question already. But we have a question that perhaps I start with that one on specifically. What are the impacts on human rights that, in this case, the Council of Europe is concerned about? In particular, our participant asks if these include impacts on social rights. And to that, I would add, okay, we have Council of Europe found these concerns, these issues. So how does the convention then aim to address them?
Okay, thank you very much. Yes, what is it we're trying to prevent? Sadly, artificial intelligence has already caused many victims. And that's not because the technology is bad, but technology, as someone said, is neither good nor bad, nor is it something else. It depends on the use that's being made of it. During the COVID crisis, much disinformation was spread, also thanks to artificial intelligence multipliers, which meant that more people than would have otherwise been the case were exposed to nonsense argument and false information about vaccination, about the nature of the crisis, about the threat. And I think probably future studies will demonstrate that a number of people, as a result, in fact, died, which could have been prevented. The same goes for so public health has been affected by artificial intelligence systems. The democratic process, we see in many countries an increase in polarization, and that increase in polarization is also enhanced through, not caused by, but enhanced through the way information is being shared, and is being shared in automated ways. More directly, and it sadly remains one of the worst use cases in the world. In my own country, the tax authorities a few years ago decided to use a very primitive, but nonetheless an automated system, which through by various definitions I think would be labeled an AI system, to detect fraud with regard to child benefits. The aim was a very legitimate one. The Netherlands had been facing increased abuse of its social security legislation, notably with regard to child benefits. And so the aim of the tax authorities to fight abuse of the system and fraudulent claims was a legitimate one. However, unfortunately, an AI system was used to detect fraudulent behavior. The data used for this in this process were totally inappropriate and should never have been used. Data on nationality, data on particular neighborhoods, data with regard to errors made in filling out forms, etc. All this should never have been used to identify criminal behavior, because it has nothing, nationality has nothing to do with criminal behavior, can never be used as evidence as such. But sadly it was. The result, and I'll cut a very long story short, the result was that some nearly 30,000 people were, in 97% of the cases, unjustly accused of fraud. It so happened that virtually all of them came from a migrant background, so non-Dutch names, and perhaps didn't master the language perfectly, so they had the wrong nationality or wrong national origins, lived in particular neighborhoods, had made perhaps mistakes in even spelling mistakes in filling out forms, and as a result were branded as criminals, had to pay back allocations, child benefits they had been receiving, but not just 1 month, but several years of benefits, which meant that people who were basically on a minimum, many of them who were on a minimum income, had to pay back huge sums of money. There was suicide. A number of very many livelihoods were destroyed. Families were destroyed. And to make it all even worse, some 3,000 children were taken away by the social services from their parents because their parents were not able to financially provide for the children anymore. As a result, there was a government crisis. The government resigned to win new elections. Problem is still not solved in my country. The children have still not been returned. Compensation, virtually all of these people are now entitled to compensation, but it's being paid out very slowly. This again was a major issue also in the elections, which just took place a week ago. So it's an ongoing tragedy. In Europe, the Netherlands is the worst case. There was a similar scandal, tragedy, perhaps better, in Australia, the so-called robo-debt scandal in Australia, where also many people, individual citizens, became victim of a non-governed AI system used by state authorities. With regard to very recent uses of artificial intelligence, since I'm speaking to a Leuven audience, you will probably remember that earlier this year, KU Leuven, several of your colleagues, Joanna, perhaps you as well, there was a letter signed asking for regulation with regard to ChatGPT-like technology to introduce safeguards after a young Belgian man was committed suicide, having been told by was not actually OpenAI's ChatGPT, but a very similar competitor, very similar product, that actually recommended suicide. And then very sadly, the person concerned took the advice and killed himself. And KU Leuven was one of the first to write an open letter, which was widely published, denouncing this and saying how much this demonstrates that regulation is necessary. So then, how is this treaty going to go about it? The first thing it will do is to, and it's a framework treaty, so therefore it will leave a lot. And the difference between a framework treaty and a normal treaty is basically that a framework treaty is more general and leaves more to national authorities to define. So the treaty gives a general obligation, and then parties to that treaty must translate that general obligation into domestic law. But because domestic legal systems are quite different, especially when, as I said, in this case, you're already 56 countries at the table. There is no there's no micromanagement through the provisions. It's more general provisions. But the convention sets out, for instance, that the parties to this convention must ensure that when they use artificial intelligence, human rights and fundamental freedoms are respected, and that they must take the necessary measures to do so. Where the jury is still out is, and now come back to the very first question that was asked, one of the first questions was asked on companies. The jury is still out whether the treaty should also contain a provision that states should ensure this not only when they use artificial intelligence or one of their agents, which may also be private actors, but acting directly, subcontractors for a government on something, but whether they should have a general obligation to ensure that any artificial intelligence that may have an effect on human rights and rule of law is subjected to the appropriate safeguards. There, the jury is still out. The argument that was made, that one of the came out in one of the first questions, namely, what about companies that think that regulation hampers innovation? That debate is still very much also going on in a few countries. The majority of states at the table would agree that we should have the treaty applicable to any use of artificial intelligence, but there are a few states which are not yet in a position to agree to this. That's all I can say so far. I can't identify them, but for you. To my mind, I think it's essential that private companies be involved. And I now speak as a member of the Committee for an NGO. The NGOs generally hold this position at the table. For me, I would draw a parallel there with the nuclear safety. If you were to exclude private companies from the scope of the convention, that would mean that would be, to my mind, similar, that with regard to nuclear energy, you would require state-operated energy companies or state-operated nuclear power stations, to be more exact, to meet certain safety standards. But as soon as the nuclear power station is independent, and in some countries, the electricity market has been completely liberalized, meaning that if you have a private nuclear power station, it would not have to meet any safety requirements. I think that is utter nonsense. I think the examples that are beginning to become evident of things that can go wrong with artificial intelligence systems, both have gone wrong, can go wrong, are such that there is every reason to consider that it's not just when they're used by the government, but when they've used full stop, that there should be regulation. So I very much hope that a solution will be found allowing the majority of the states at the table to go ahead and to adopt a treaty with this obligation, finding a way to accommodate the very few countries that are not, and I would say not yet, in a position to also accept this. A question was also raised about social rights. Of course, social rights are human rights, and therefore it is clear that when human rights are mentioned in a treaty, this also refers to basic social rights. In fact, the European Social Charter is explicitly mentioned in the draft preamble, next to the European Convention on Human Rights. It's one of the sources of inspiration for this treaty. Then there are a few, and I'll give you a few other examples. The idea is that the treaty will deal with the full life cycle of AI systems. So not just about the final product, but already from the design phase, so that during the design, the development, the deployment, and the decommissioning, if you like, at the end, when we change systems for new ones, that through this whole life cycle, a number of guarantees are there. The guarantees that are in the substantive draft are all very similar to the ones, and I'll rapidly name them, but you will find them also in the OECD and UNESCO proposals. The difference being, although I should stress this here, that the UNESCO and OECD principles are recommendations. There's policy advice, excuse me. Here in Council of Europe, we're talking about a treaty, about binding law, which can be used before court. Courts can supervise, should supervise. So there's a big difference, even if the terms are very much alike, but it's good that the terms are alike. So we have transparency and oversight. It should be clear when artificial intelligence is being used. It should be made clear to the citizen and or the user, if we include the companies generally, that they are using artificial intelligence. There should be oversight. I would add competent oversight. In the example I gave you of the Netherlands, there was no oversight. There was no transparency. No one knew initially what data were being used at all. Secondly, there was no oversight. It was the system that said these people are criminals. They have defrauded. No one asked the question, why these people? Why not someone else? Had it been civil servants, humans, that had come to the minister or the director general of the tax authority and said, oh no, we have a list here of 30,000 people, they are the criminals. A minister would have asked, how did you establish this? And if the civil servant had said then, yes, well, we looked at the nationality, we looked where people lived and whether they could write Dutch, and if they tick negatively in these boxes, we consider they're criminals. In such a case, the minister would have I would hope, most ministers would have said, well, back to the drawing board and do your homework again, because this simply is not acceptable. But there was this sort of blind faith in the capability of computer or a computer system, or an automated, even better AI system, to come up with impartial and unchallengeable results. The University of Amsterdam organized a conference about a year and a half ago with the interesting title, the computer said it was okay. There was this blind belief, and it used to be called, I used to call it automation bias, this blind belief, but there was a better term coined by one of your colleagues, Joanna, in Leuven, when I was in Leuven earlier this year. And he said, Jan, a better term would be cognitive shutdown, which I fully agree with. It's as if one closes the blinds in one's mind. This is automated, this is AI. I cannot possibly challenge this. Yes, you should challenge it. You should very well challenge it. So this oversight is absolutely necessary. And then accountability and responsibility, also very necessary. If you roll out systems, there is accountability, and there is always, I should add, human responsibility. This has also been a subject of debate. Should artificial intelligence have legal personality or not? I don't think it should. Artificial intelligence systems are artifacts. It's silicone, it's semiconductors, it's electric currents. It's not human responsibility. A machine cannot take responsibility, nor can a machine be responsible. It is those that operate these machines, those that design them, that develop them, or those that authorize them to go on the market that are responsible. So there is accountability and oversight. Another element in the treaty will be equality and non-discrimination. We have seen, and you will have read about this, most of you, that many of the systems, because of the data used to train them, are heavily biased, racially biased, gender biased, ethnically biased. There are all sorts of biases in the system. And it's very important that this be recognized and addressed. Privacy and data protection, of course, are very important elements, as are safety, security, and the robustness of systems, and also safe innovation. We then come to another issue, which in the Netherlands demonstrated, where the Netherlands demonstrated how difficult this can be. Namely, that not only should there be all sorts of mitigating and risk-reducing elements, the ones I just mentioned, make sure that it is being used in the best possible way. However, one should always be realistic enough to realize that even with a very good use, things can still go wrong. Things will go wrong, and therefore it's important to have effective remedies. You must be able that if, despite all these safeguards, things still go wrong, and believe me, they will, that there is a possibility for remedies. In the Dutch case, that remedy didn't exist. It existed on paper, but when the people who were wrongly accused by the tax authorities through an automated system did go to court, the court said exactly what I mentioned earlier. The computer said it was okay. We're simple judges. Who are we to challenge this? This has since been recognized, and now reforms are underway, for instance, in the Dutch administrative system. But it's very important to have appropriate remedies. Personally, for instance, I have proposed, and I will insist on this, that we have in courts, we have, as you know, criminal chambers, we have tax chambers, we have civil chambers, and we should also have digital chambers or AI chambers. We should have judges who they don't have to program or design AI, but they should be sufficiently aware of its possibilities to ask the right questions. So we do need judges in our courts who have a basic understanding, a grip on what these systems can do, what they may do, in order to be able to, just as I say, a tax judge doesn't have to write tax legislation, but he should understand it sufficiently to be able to judge a case which involves tax matters. So remedies very important. Then procedural safeguards, which is also very important, is awareness raising and training. It's training of people who operate the systems, training of people who are supposed to supervise the systems, the oversight, and very important that there is also general awareness in the general population of the risks and issues relating to artificial intelligence. For instance, an idea is that when governments use AI, they should always inform the citizen that the particular communication is being made, or the particular decision or measure is made through an AI system, and so that the citizen knows this. And if extended to private companies, that the user generally knows this. Oversight mechanisms, national authorities, important. International cooperation to ensure that once this treaty is adopted, we keep it up to date through very regular meetings, I would hope at least once per year, of all the parties to the convention to discuss how it's being implemented at national level and what can be done to improve matters. And of course, to take into account new developments. When we started this work, no one had heard of ChatGPT and foundation models. Now they're, of course, the big issue. And I promised I would come back at the end of my presentation to something also in the European Union. I said the EU AI Act is under negotiation, but we have very recently seen an attempt by at least 3 states to exclude foundation models from the high-risk applications, from the high-risk definition in the system. Fortunately, I say fortunately because I think this is totally wrong and irresponsible. And the European Parliament, fortunately, has already made clear that it will defend very strongly the inclusion of these systems. I think it's very important that they be included, because if you take ChatGPT for instance, I find it quite extraordinary that such a powerful technology is actually being tested on the world's general population. Just imagine a car manufacturer rolling out a vehicle, selling it to the public, and say, well, no, have a go. We don't know whether it brakes or whether the steering wheel works or whether it has light or whether it does anything. Just drive around, and if you crash, and then we know, what to fix. That's more or less what's happening with ChatGPT. It's being rolled out. You use it, you crash, you hurt yourself, you hurt others, and then we know as a company what goes wrong. Is that the way we want to go about such a powerful technology? I would doubt it. So I very much think that these models should also be included in the EU AI Act, and also within, of course, the obligations with regard to the Council of Europe Treaty. I stop here for a moment, Joanna. I think it's also have a look at the time to perhaps have a final round of questions.
Yes, thank you very much, Jan. You already were mentioning a lot of questions of scope earlier about uses by public entities versus private entities. And we have one of our participants asking about law enforcement and migration, if this would be within the scope, because we know that there are civil society organizations, for example, in the case of the EU AI Act, asking for this to be within the scope, considering its effects on particularly vulnerable people. But then there's a push on the other side to have some exemptions for these areas. So is this push also seen in the negotiations in the draft treaty? What's the state in this case?
In the case of the Council of Europe, it's very much included, because the wording that so far has been agreed is that, and I have not yet seen, but as I said, there's a round of negotiations next week. So, of course, do not know what certain countries may come up with next week. But so far, there seems to be agreement that the Council of Europe Convention at least shall apply to any use of AI systems during their life cycle that have the potential to interfere with human rights, democracy, and rule of law. So in that case, the issues that were mentioned by the person that put the question would certainly be included. And because we, as I mentioned, there also appears to be an agreement, even consensus at the moment, that it should apply to state agencies. Rule of law would definitely, law enforcement, would definitely be included in the law enforcement agencies would definitely be included within the responsibilities of parties to the convention.
Thank you, Jan. And we have a question about about oversight and human responsibility that you were, of course, explaining just a moment ago, and specifically on with the black box phenomenon. This can be quite challenging. So how exactly to ensure oversight and human responsibility with this characteristic, or if there should be incentive on states to somehow ban it or reduce its development and use?
No, the idea is that the states under the framework and the Council of Europe Convention at least should, as I said, it's a framework convention, so it doesn't go into the not only not into the nano, but not even to the micro level. States would commit to ensure that their accountability and responsibility throughout the life cycle is ensured. It's indeed, it will be very interesting to see how that is going to happen. Oversight bodies are mentioned, necessary oversight bodies. I know there's a lot of pushback against disclosure of at least the basic algorithms, let alone what happens afterwards once they have been they start working. What happens in the black boxes? But here also, again, I would draw a parallel with the pharmaceutical industry and even the Council of Europe experience. Within the Council of Europe, there is the European Pharmacopoeia. Next to the office where I used to work, the legal services, if you like, there are huge laboratories here in Strasbourg where medicine is being tested on the basis of the original ingredients to ensure that if you buy an aspirin in Portugal or in the Netherlands or in Belgium or in France, that contains the same molecules and has the same safety standards. To that end, pharmaceutical companies have shared with the pharmacopoeia the original, all the original recipes. And of course, the pharmacopoeia doesn't share that with the public. So it's all patented, and in some cases, but it's and the dosage, but it's all being checked. I was at a conference last week, 2 weeks ago in Zurich, where a Canadian company participated, a very successful AI company, saying that all their algorithms are public and have been shared with authorities. So the fact that none of this could possibly be shared or could possibly be assessed, I think, is also not true. There are examples to the contrary. To what extent, however, countries will do that, as I said, it's a framework convention. It's the states that will have guarantee that things are being done. How they do it will, in many cases, be left to themselves. That is not to say it won't be checked, because this conference of the parties or committees of the parties at the end will be set up. I'm convinced that's also General Council of Europe practice to assess and to assess the implementation of the convention, and therefore states already vis-a-vis each other will have to ensure that what they promise to do will be done. And very importantly, at national level, since we are speaking about legal obligations that have to be transposed into national law, national courts will be in a position to, if someone challenges it, to ensure that so there will be a remedy, and someone who claims to have been a victim of algorithms used or systems used by state authorities will have the possibility to go to a court, and then it would be for the government in the minimal option of the convention, and perhaps hopefully, if we have the larger version, also private companies, to demonstrate that they took every precaution to avoid harm.
Thank you very much, Jan. I see that Professor Valk has joined us, so I think I will go straight to her, taking into account the time. Jan has already given us a lot of insights into the KAHAI and the KAI and the text of the convention, but we are, of course, very much looking forward to your perspective, Peggy, in this as well. So you have the floor.
Thank you very much, Joanna, and also many thanks to Jan, and apologies to you and also to the audience for joining so late, and also for just a limited time, but unfortunately I had a double booking in my calendar. So I'm happy to be here with you and give you my perspective, having followed the activities of KAHAI and KAI as the head of delegation for Belgium, and also as the co-chair of the first committee that was set up, the KAHAI, to prepare the activities that we're currently going through, namely negotiating an actual treaty on artificial intelligence. So what is my perception of the process, and especially then the last months, and I hope I'm not repeating too much what Jan has already said. I'd like to start with underlining the importance of this endeavor. And I'm sure that this is something that Jan has also brought to the fore. Often we hear, yeah, but what is the added value of the Council of Europe's activities? We already have the AI Act in the European Union. Well, what the treaty at the level of the Council of Europe will bring is that it has, first of all, it's a different focus. So it focuses very strongly on human rights, democracy, and rule of law standards, rather than as the AI Act, which is mainly an internal market instrument focusing on standardization and, yes, taking safety and fundamental rights into account, but above all, it is an internal market instrument rather than a human rights instrument, like is the case with the AI Treaty of the Council of Europe. And secondly, what it will, the added value of the treaty evidently lies in bringing together a broader group of countries committing to respecting certain human rights standards in the area of development and use of artificial intelligence systems. And that brings me to my second remark. What we've seen in the last months and years is that the group of countries sitting around the table has increased. So also in Kahai, we had a number of observer states already following the activities of Kahai, but they were less, I would say, less active. As now with the treaty negotiations themselves within the CAI, they take up a more active role, and that group has also broadened. Lately, we had 4 Latin American countries joining the negotiations, and before that, we already had the United States and Canada and Israel and Japan also being quite active. And that is, I think, a very important aspect of this treaty, whereas we have in other fora, like the OECD and the United Nations, UNESCO, we have also initiatives on AI governance, but those initiatives have only moral and not a legally binding value. And this is something that the treaty at the level of the Council of Europe can add or can bring to the discussion to offer a global binding instrument on AI systems. So, of course, this broadening of group of countries has led to a third aspect I wanted to highlight, and that is that I've witnessed a move from coming up with quite detailed provisions. I was chair of a subgroup of the CAHAI, the legal frameworks group, where we actually already drafted quite detailed provisions, but that level of detail has gradually diminished in order to find common ground for a broader group of countries. And now the discussions revolve quite intensely around this dilemma. Do we want to sit around the table with more countries, even though that leads to less detail in the text? And for the moment, there is a strong urge to have this broader group of countries committing to certain standards, even if that leads to a more principle-based approach, because the underlying idea is we're working towards a framework convention. So this is a first step only, like setting or laying the basis for the skeleton for then perhaps further in the future more binding instruments in particular sectors or on particular aspects, further fine-tuning it in subsequent treaties that either all or only a number of parties can commit to. But now we're working, or the trend is going in the direction of let's build a skeleton, a framework of principles, values that a group of countries as broad as possible can adhere to and can commit to as a binding instrument, which means that there will be follow-up mechanisms. I heard Jan talking about there will be courts overseeing whether the treaty is respected, and also the parties to the convention, they will meet regularly and hold each other to account. So this is what matters, to have this common framework and then see as AI systems develop, because this is a moving target. When we started the activities of CAHAI, generative AI and ChatGPT was not even mentioned. So to have this common framework now and then together work towards more detailed provisions as the technology also develops. So yeah, this is important part of the discussions now. What will be the exact scope of the treaty? How detailed can the provisions be? What level of detail can we reach without losing parties that we now have around the table and are willing to talk and come to common ground at a global level.
Thank you very much, Peggy. We don't have much time, but I'll perhaps just still ask one or two questions,
Sure.
because we've been touching upon throughout the webinar, points of diversion that still need to be resolved before the treaty is finalized. So a question to both you and Jan. What are these strongest points of divergence? What seems to be the most pressing issues now that need to be agreed between all of these actors involved?
Would you like to start, Jan, or shall I start?
Okay.
Sorry, your microphone is muted.
You're muted.
Yeah,
Yes.
sorry, I muted when you were speaking. Sorry. Yes, two issues. One is the issue of private companies. Should they be included or not? Said there are some states that are not yet at this, as we speak today, in a position apparently to agree that it also extends to them. But of course, solutions can be found. In Council of Europe treaties, there are both opt-ins and opt-out wordings, precedents in other treaties. So we can see what we can do with that. A second set of issues is the sort of exemption you would have for national security. In the European Convention on Human Rights, national security can be invoked by a state, but under very strict conditions. There's never a blanket exemption just because a country says, this is national security, therefore I can do what I want. That has never been accepted in Strasbourg. It's always, you can say that, but then it should be necessary in democratic society, lawful, it should be proportionate. There are various tests to be applied. So that's also something where the jury is still out. Very much hope and trust, and I'll then give, of course, immediately the floor to Peggy, that in any case, that the blanket exception will not be retained, and that when it comes to national security, any exceptions it will be said that national security exceptions will have to meet a certain precise criteria as found in other treaties.
Yes, those were exactly the points I also wanted to mention. That's what I meant when I referred to there's a lot of discussion on the exact scope of the treaty, namely should it include public actors and private actors when they act on behalf of public entities, or also private actors in general. Now, I think there's a strong will to work towards a scope that includes both public and private actors. And then the question that is then still left to be tackled is, okay, but how to operationalize the principles in the treaty towards both categories? Can we make a distinction there? That, for instance, for public actor entities, binding national legislation is required, whereas for private actors, you can allow parties to the treaties to work through other regulatory instruments like self-regulation, codes of conduct, or existing rules. So that's a type of discussions we're having right now. And that's, we hope to take a step further next week at the 8th plenary meeting in Strasbourg, because the aim, something that probably was mentioned before, the aim is to wrap this up in spring next year, March, April. We should hopefully have a final text of the treaty. I also like to underline that there is already strong convergence on many aspects, and there was convergence, for instance, from the start on the risk-based approach, the type of rights and principles that had to be included, or that definitely had to be included, but then we're discussing details, that there should be procedural safeguards also for citizens in certain areas. So, I mean, yes, we still have some knots to tie or untie. I don't know what the exact expression is in English, but we have already reached the convergence on a lot of aspects.
Thank you very much. We are very much at the end of the webinar, but before we close off, I'd just like to ask for your concluding thoughts, and perhaps let's start with Jan and then go to you, Peggy. What key messages do you want our participants to take away from the webinar and from this process that we've been discussing?
Thank you very much. I'll be very short. Key message, something that perhaps didn't come out so much because earlier in what I said is that, of course, artificial intelligence can also bring enormous benefits to humanity. So it's not all, certainly not all negative. I said technology is neither good nor bad, nor is it anything in between. But it can bring huge benefits, and therefore I'd like to end with a quote from a very famous, since we're also speaking to a lot of lawyers here, a very famous British lawyer, the first QC ever, Francis Bacon, who served under Elizabeth I. He had a very interesting statement about money, but I think it's most appropriate also to artificial intelligence. He said, it's a very good servant, but a very poor master. And I think that is something we should keep in mind when dealing with artificial intelligence. So with this thought, I'd leave it to Penny. Thank you all very much for your attention. It was a pleasure speaking to you.
Thank you, Jan. I guess I'd like to repeat what I said before, the importance of having a group of countries sitting together beyond countries beyond Europe only, that discuss global standards, common standards for AI technology, because this technology, it's not European technology, it's not American technology. I mean, these technologies are being developed and will be used worldwide, and therefore it's important to come to a form, at least a minimum form of standardization at the global level. And this is something that we can reach through this AI treaty, even though at first sight, people who see the text for the first time might be a bit disappointed. Is this it? As I said, it's very much principle oriented, but it is a necessary step towards binding standards, ensuring that this technology is being developed with human rights, democracy, and rule of law, taking that to heart in the development, so that this technology can serve humankind and not only economic interests.
Thank you very much. These were very interesting insights into the Future Convention on Artificial Intelligence. Unfortunately, we have exhausted our time for today, but both of our speakers have given us plenty of food for thoughts. So thank you for that. And thank you as well to our audience members for taking part in the webinar and asking so many questions that unfortunately we didn't have time to go through all of them. So that's it from us today, and have a good evening.
Thank you very much.